Yes, students, let us now deal with lesson 3. Lesson 3 will be where we deal with bail. Okay, we deal with bail and other forms of release. So there is also somebody can be released on bail, somebody can be released on warning, somebody can get a warning police bail as well, where you are released at the police station before you even appear in court. So let us deal with those. Now, the legislation that I'm going to refer you to is in the Criminal Procedure Act. So you look at sections 39, you look at section 50, you look at section 59, you look at section 59A. So these are the different forms of releasing somebody who has been arrested. Remember, we talked of section 12, where in section 35, the rights, section 35 of the Constitution, section 12, the right to freedom and security of a person. Because if you're in jail, you are not safe, you can be stabbed by other prisoners, and you don't have your freedom. Also, section 35 of the Constitution talks of the rights of arrested and detained persons. So now we go and correlate those with the Criminal Procedure Act. So I said you look at section 39, section 50, section 59, section 59, capital A, right? And also section 59. Look at those two section 59. The section 59 and also the section 59, capital A. You need to look at that. And there's also section 60 of the Criminal Procedure Act. And also, like I've said, you look at section 35, subsection 1, and subsection 1, subsection F of the Constitution. And also look at section 35, subsection 3, subsection H of the Constitution. It talks of arrested person and their rights. Okay. The cases that you can, when you do your closing argument, for instance, in the bail application, you can use a case of Maqungu. Maqungu, it will be MQU NGU versus Assistant Magistrate Whittlesea, 1977. Volume 2, SA 359E. That is the seat of the court. Right? I think it must have been the court in the Eastern Cape, that E. Okay. So now, like I've said, when we are doing our classes, we will be discussing questions, possible questions in your exams. So the question will be: discuss the provisions, limitations, and discretion relating to the granting of bail by the police, which is called also police bail, before the first court appearance of the accused. And I give you 5 marks, right? So now the answer will be, this is how you're going to try to answer, right? 1, procedure concerning police bail, that's your heading. Procedure concerning police bail. Police bail may be granted in respect of any offense other than an offense referred to in Part 2 or Part 3 of Schedule 2. Right? I repeat, police bail may be granted in respect of any offense other than an offense referred to in Part 2 or Part 3 of Schedule 2. So you go to your Criminal Procedure Act, right? Criminal Procedure Act. You go and look at it. You will see the schedules there. It will tell you which one is Part 2 or Part 3 of Schedule 2. Which crimes fall under that schedule. That's a no-go area. That person under those schedule in Part 2 and Part 3 cannot be released on police bail. That means they've got to go and do a formal bail application where? In court. Right? Such bail may be granted by any police official of or above the rank of non-commissioned officer. Right, so those bail can be given by police, not any police, a police officer, right, above the rank of non-commissioned officer. Non-commissioned officers are those police that you don't salute, right? They are called non-commissioned. The non-commissioned officers will be the lance, is it the corporal? I don't know whether it's corporal. There's corporal, there's constable, there is lance, right? When you go to colleges, there's something called lance sergeant. They're not sergeant as such. Sergeant cannot give bail. Warrant officer cannot give bail, right? But now, I think, there's another rank called inspector or captain. It starts there. Then those are commissioned officers. Those people, when you come to them, you salute them. You do this. You salute them. Are called commissioned officers. Those are the people that you can release your client on police bail, right? No one else. If you do that with the constable, you will be in trouble. Don't be part of that. Make sure that the person who is releasing your client is a commissioned officer, is not a non-commissioned officer. Anything below the rank of captain is a non-commissioned officer, so they cannot grant bail to anybody. Otherwise, it will be irregular or it will be wrong. The person will be recommitted to prison because the person did not have the right to do so. Okay, so remember the non-commissioned officers. If the accused deposit at the police station the sum of money determined by such police officer, then that person can be freed of bail. That is now in terms of section 59, subsection 1, subsection A of the Criminal Procedure Act. You deposit money in lieu of bail, and then let's say bail is 200 rands, you pay 200 rands and you are out of bail. Sometimes it's 5,000 rand. You pay that money and you are out on bail. You get what is called police bail. Okay. The police official who determines police bail is, however, statutorily required to consult with the investigating officer before granting bail to the suspect. So that officer has a duty to do what? To consult with the investigating officer before he grants that bail. So you can't just give it willy-nilly because you're going to jeopardize what? Maybe you're going to jeopardize the investigation. Maybe there's still crucial information that the investigating officer needs before somebody is released, and that person goes and destroys that information. Then the case is jeopardized, right? The suspect shall, on payment of the determined sum, be furnished with a receipt setting up the place, date, and time on which the suspect is supposed to appear in court. So that person must be warned to say, listen, you are released on bail, you don't interfere with witnesses, you don't interfere with the investigating officer, and make sure that you appear in court on such and such a day, and if you don't appear, bail will be forfeited to the state and you will be committed to prison. That is what happens, right? The police official must forthwith forward a duplicate original of such recognizance to the clerk of the court which has jurisdiction. So, and then what you will do, once you've given them that receipt, that bail receipt, a copy of that will be attached in the docket and be handed over to the clerk of the court, right? Clerk of the court where the person will be here, or where the crime was committed. That is now the court with jurisdiction. Okay. Now let's come with the limitations now of police bail. Police bail, the limitation. Police bail is only limited to the period before the accused's first appearance in a lower court and is only payable in cash. Sureties are not acceptable. You cannot say, no, I'll leave my car here and then come back and pay bail. You pay bail, you pay it in cash, and you can only do it only before a person appears in court. Once a person has appeared in court, police have no business in doing that, in giving that person a bail. It's only the court now. That's in the court territory. You can only give bail if a person has not done his or her first appearance in court. Once he's done her first appearance, then it becomes the prerogative of the court to grant bail. Okay, that's fine. Now, there's something called the discretion. What discretion can do? Excessive amounts should not be fixed, which would essentially deny bail to the suspect, even if you are, it's whether it's in police bail or in court. Because if you say, okay, I grant you bail, but you must pay R1 million, that's as good as denying that person bail. So it cannot, and you can support that argument, because if you when you are a lawyer, you don't just say, a advocate said no, you can't grant so stringent bail because it's just as good as denying that person bail and violating his constitutional rights. You don't go to the Constitution. You must also quote a case, right? You can quote the Constitution, right? In terms of Section 12, the right to freedom. You can say that as well, and also the Section 35 of the Constitution. You can invoke that, but also you must use case law. The case law will be Shaw versus Collins, right? 1883, Volume 2, SC 382. That's the case that you can invoke to support your argument. But it's an old case, 1883 case, right? Volume 2 of the Supreme Court at page 389. So that's very old, but you can use it. You can use it to support your statement, right? Right, now let's come to the constitutional right to bail and the need for and nature of bail as a method of securing liberty pending the outcome of a trial must be understood in the light of certain principles. That could be the question. All I say, I just give a statement and say the constitutional right to bail, right, which is Section 35. Section 35 of the Constitution, right, talks of arrested and detained persons. So I say now, I give you a statement and say the constitutional right to bail and the need for a nature of bail as a method of securing liberty pending the outcome of a trial must be understood in the light of certain principles. And then I say, discuss this statement, right? Because I told you we are discussing questions, and the answer would be right to apply for bail. Every suspect has the right to be released from detention in the interest of justice, if the interest of justice permit. Everybody has a right to be released on bail, right? That is not admitted to bail, if you like, subject to the reasonable conditions. Then you put conditions. Conditions will be in terms of Section 35(1), subsection F of the Constitution. It could be that the person must sign at the police station once a week, or a person must hand over the passport, or a person is not allowed to leave the Republic. Or if he wants so, he must consult with the investigating officer. You go to the investigating officer and say, I want to go to Swaziland, please, can I have my passport? Can I get permission to go there? And then if the IO says you can go, then you go. Those are the conditions, right? Something called presumption of innocence, right? The Constitution guarantees the accused's right to be presumed innocent in the absence of a conviction by a court of law. That is now Section 35, subsection 3H. So you are presumed to be innocent until proven otherwise. That is now the provisions of Section 35. Bail is therefore a method of securing a compromise between the pretrial detention of a suspect and the presumption of innocence. So you've got this is called a bond, bail bond. You pay the bond that makes sure that it secures your attendance to the bond. The purpose of bail is also to strike a balance between the interests of society The accused should stand his trial, and there should be no interference with the administration of justice. And also the liberty of an accused who, pending the outcome of his trial, is presumed to be innocent. Right? According to the legislature, the refusal to grant bail shall be in the interest of justice, where one or more of the grounds referred to in section 60, subsection 4A to E are established. Then you need to establish that if this person is released, it will be in the interest of justice. So the provisions are there in section 60. If you read subsection 4 of the Criminal Procedure Act, 60 subsection 4 of the Criminal Procedure, from A to E, it will tell you what do we mean by the interest of justice, right? The person doesn't interfere with witnesses, doesn't go astray or attends the trial, and doesn't interfere with witnesses and investigating officers, okay? Doesn't destroy evidence. All right, the whole issue turns on what is the best interest of justice and revolves around the consideration of whether, firstly, the accused will stand his trial, and secondly, whether he will not interfere with the state's case, like I've said. If any further development and interpretation of the rules and principles governing bail, all courts are obliged to take full account of the provision of section 39, subsection 2 of the Constitution. That is, a court must promote the spirit and purport and objects of the Constitution all the time. That is the provision of section 39. Okay, let us then hold it there, go and read Criminal Procedure Act, read section 60, especially subsection 4 A to E. It will confirm what I'm saying. So whatever I say in these classes or mini classes, go and confirm them with your Criminal Procedure Act book, right? I think, yeah, go and do it. Do it now before you forget.